Welcome, everybody. It's 10 o'clock. You don't really need an introduction for me, I don't think. You all know that I'm here because I couldn't get anybody else to show up on a Tuesday morning at 10 in the morning. But since it is election day, I thought we should talk about elections. And I couldn't figure out what to put for a title because from what I could tell, the history of voting in this country has all been about gerrymandering and manipulation and suppression and all sorts of things. So I tried to tone it down a little bit, but it is what it is. So I'm going to talk about sort of historically the various different regulations and voter suppression techniques and various things that are going on, and ultimately end up talking about partisan gerrymandering and the case that's before the Supreme Court right now about the Louisiana district, new district maps. So the Constitution doesn't have much about voting. They leave it to the states. So the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. That right there leads to some issues. Do they really mean the legislature, or what about the governor? Or what about a public referendum? Can you have a public referendum that's going to change how representatives and senators are chosen? So we've seen here in a number of states public referendums to impose redistricting commissions to sort of remove that from the hands of the legislature. Question whether that's constitutional. It is, fortunately. But we also have the provision that the Congress at any time can make or alter such regulations. So there is scope there for Congress to pass laws affecting elections and how we do them. So for about the first 50 years, it appears that the states just flip-flopped back and forth, generally with every election, between a districting type of election where you elected Congress people based on districts versus just a statewide election where everybody in the state elected all of the representatives for that state. And they went back and forth sometimes with every election, depending on who won in the state house. But in 1842, the Apportionment Act mandated single-member districts. And so I just paused there for a moment to think about that. We have 28 districts in the state of Florida. Imagine if we had statewide voting for our Congress people. We could vote for all 28. We wouldn't be limited to voting for a representative to represent our district. And of course, if we elected them statewide, we would not have fights over how we divided up the districts and how we put people into different districts. But that decision was made in 1842. It was recodified in 1967, and I don't see us going back from that. Right now, one congressperson represents about 760,000 people. So each district is supposed to represent about 760,000 people. Originally, they wanted to make sure that it was at least 30,000. 30,000 was the original number when the Constitution was first being framed. So to imagine going from representing 30,000 people to representing 760,000 people. Between 1878 and 1896, there was really intense partisan gerrymandering because the state legislatures swung between different parties. But since 1896 to 1964, relative stability, because state legislatures, state houses have not swung as much. And so there's been far less partisan gerrymandering up through the first half of the 20th century. You had red states and you had blue states. Pretty much had red states and blue states since the turn of the 20th century. Now, it's interesting that obviously in 1787, voting was limited to white male property holders. And the Constitution left it to the states to determine who's qualified to vote, so how much property you had to have. But there have been 5 constitutional amendments on voting. And when you take away the Bill of Rights, the first 10, which are on liberties, That's almost 1 in 3 of our constitutional amendments have addressed voting. So in 1870, we extended the vote to Black men with the 15th Amendment. In 1913, we went to popular election of senators rather than the legislatures choosing senators. In 1920, women got the right to vote with the 19th Amendment. 64, poll taxes were rendered unconstitutional. And in 1971, 18 to 21-year-olds got the right to vote. So that's 1 in 3. So voting has been a topic of great interest in this country. But probably the worst part happened post-Reconstruction. So post-Reconstruction, once we had the 15th, the 15th Amendment after 1870, we started to see a lot of voter suppression, particularly of the Black vote. And so poll taxes, literacy tests, English language requirements came in following World War I, closed primaries, residency requirements. States could up their residency requirements. There was one rule called the 8-box rule. There would be 8 different boxes, and you had to put up your ballot in the right box. You had to vote for different issues. You had different ballots, and you had to put them in the right box. And if you got your ballot in the wrong box, and they were labeled very tiny, your ballot didn't count. So just efforts to keep people from voting, make it as difficult as possible for people to vote. In Louisiana, being one of the masters of voter suppression, there were only 5,320 Black voters on the rolls in 1900, despite being a majority of the state's population. Only 5,000 voters were allowed to register to vote in Louisiana. So in 1965, we get the Voting Rights Act, massively important piece of civil rights legislation. It passed with bipartisan support in the Senate and the House, and it was amended a number of times to eliminate literacy tests, because poll taxes were eliminated by the 24th Amendment, but the literacy tests were not eliminated until the Voting Rights Act. 75, we expanded it to protect language minorities. So if you have a pocket with a large population that speak a different language, election ballots were required to be in a different language. The Voting Rights Act was expanded in 82 to protect people with disabilities, and the motor voter law was expanded to allow people to register when they get their driver's licenses. So the Voting Rights Act, and it was reauthorized in 2006. Following our hanging Chad debacle here in Florida, we got the Help America Vote Act, which required replacing outdated equipment, statewide voter registration lists, things like that, to facilitate the vote. So we see this, the country has swung and states have swung back and forth between voter restriction rule efforts and voter expansion efforts. But the Voting Rights Act is a really important statute, and it's been litigated. I'm sure you've heard about it in the news. So Section 2 of the Voting Rights Act basically says no discrimination or abridgment of the right to vote on the basis of race. So it's just a law that affects race, and it prohibits discrimination in how we establish voting. So the Voting Rights Act will affect things like ID requirements, registration requirements, literacy tests, poll tests, that sort of thing, poll taxes. But it also can affect how we draw districts. And it's really the intersection of the Voting Rights Act with how we draw these districts that has really sort of come to the fore right now. So Section 2 says no discrimination, and you can abridge the right to vote as long as you do it equally. So long as we all have to register to vote, that applies equally to all of us, as long as it's not intended to restrict on the basis of race, and it doesn't have any disproportionate impact on the basis of race. The obligation to register does not violate the Voting Rights Act. So you can abridge the right to vote, but you cannot do so with an intention of um, diluting on the basis of race. Section 4 provides that if you have any kind of tests or prerequisites, like a literacy test or a poll tax or things like that, those cannot abridge the right to vote. And then without a court judgment. And then Section 5 says if you want to change, if the state wants to change its laws to add some kind of restriction, whether it's a new ID requirement, you provide proof of citizenship, that kind of thing, they have, most states are going to have to get, well, not most, the 15 states that are under judicial orders are going to have to get pre-approval from a court or the Department of Justice in order to make those changes. So Section 5 and Section 2 are the two sections that have been litigated recently and have been dramatically affected. But the pre-clearance requirement says if you want to make any change, you have to get a prior permission, not forgiveness afterwards. So Shelby versus Holder in 2013 was a Supreme Court decision that essentially nullified Section 5. It didn't it did. Because what it said was it held that states and localities that have a history of suppressing voting rights, so the 15 states that were under pre-clearance requirements, that they no longer have to submit their changes in election laws to the Department of Justice. So those 15 states that have a history of repressing the vote no longer have to get pre-clearance if they want to make changes. So immediately, states went to town. Texas, Alabama, Mississippi, North Carolina, Virginia enacted voter ID requirements that had been blocked by the Voting Rights Act. Now, what we also see is that, well, what we will see is that some of this ends up in federal court, some of this ends up in state courts. So some of these are states saying you're in violation, so that certain restrictions on voting may violate certain state laws or state constitutional provisions. The North Carolina Voter ID Act, though, was struck down by a federal court on the grounds that it targeted African Americans with almost surgical precision. I didn't actually read the case, so I don't know. But a number of, let's just say, shenanigans have been happening since 2013, since Shelby v. Holder. So districts increased lines by reducing the number of voting machines. And that's just something that the supervisor of elections can do. They can just reduce the number of voting machines so that the lines look long, so people choose not to stop and stand in line and end up not voting. Deliberate misinformation about voting locations and deadlines caused many ballots to be deemed invalid. There's a number of sort of scandals of different people sending out notices saying, "Oh, your precinct location has changed," and then it turned when it hadn't, to certain people. 2016, the Texas ID law was struck down because it allowed military IDs and driver's licenses, but would not allow government employer photo IDs or university IDs. So it was struck down as under these are all the ones that have been struck down were struck down under the Voting Rights Act. However, laws prohibiting student IDs were passed in Wisconsin and North Carolina. Now, why are we going to prohibit student IDs? We don't want students to vote, right? We don't want students to vote. Students tend to vote on the left more often than not, tend to vote Democrat, and so these laws prohibiting student IDs have been upheld. In 2018, 23 states passed laws creating obstacles to voting. They closed locations, they required IDs, they limited mail-in ballots, they shortened the early voting period. But in 2020, with COVID, states took extensive efforts to expand voter access. And in the 2020 election, we had the highest percentage of voters voting since 1900. because of these efforts to expand mail-in voters voting. Now, in 2023, that North Carolina ID Act that was struck down back in 2015 was upheld and went into effect, the exact same North Carolina law. And in 2024, 10 states passed restrictive voting laws, and lawmakers in 40 states considered more than 300 bills aimed at making it harder to vote, most of them requiring proof of citizenship. So these are just laws that are just regulating how we run our elections. And many of them have run afoul of the Voting Rights Act, but now that the pre-clearance requirement is gone, now you have to wait until the laws go into effect, wait and see if they have a disproportionate impact, or if they in fact do abridge the rights of Black voters. Voting Rights Act litigation has continued at the Supreme Court, and the next important case came out of Arizona. So Arizona passed 2 laws restricting ballot collection. So you couldn't, they called them ballot harvesters. You couldn't go and get a whole lot of absentee ballots and take them down to the supervisor of election. Only people who could handle ballots were family members, and you could only handle 1 or 2 ballots per person. And they passed laws that restricted out of precinct ballots. So if you had moved and you went to your old precinct or whatever, and those, any ballot that was cast by someone who was not in the right precinct was deemed to be invalid, as opposed to allowing a provisional ballot for them. In 2018, the district court upheld those laws, as did a 3-judge panel of the Ninth Circuit, but the full en banc panel reversed 7-4, holding that those Arizona laws were a violation of Section 2 of the Voting Rights Act, that they abridged the rights of voters on the basis of race. And they held that they were passed with the intent to discriminate. That case went to the Supreme Court, and the Supreme Court reversed again, and said, no, these laws are fine. These laws are fine. But they reinterpreted Section 2 of the Voting Rights Act, and this is really important. So the Section 2 of the Voting Rights Act says you can't discriminate or abridge the right to vote on the basis of race. And the Supreme Court in Brnovich said, well, we'll let you change and impose restrictions because you have based on a claim that you have a fear of election fraud, but you don't have to have any evidence that that fraud occurred, nor do you need evidence that the new restrictions would make elections safer. If you just say, I'm afraid of election fraud, that's good enough to justify the laws until we see that there is greater impact. Okay, so, and we don't know. Well, we're continuing to fight this battle. So, could you move that so I can see what I wrote up there? Oh yeah, between 2020 and 2024, though, many states have really tried. Actually, I think we've seen a lot of what do you call them? Your supervisors of elections have really tried to expand voting, make voting easier for people. We have greatly increased the unrestricted mail-in voting in 2020 from what it was in 2016. But there's a lot of pressure to restrict that kind of voting. We've also, as we know in Florida, we've been battling over re-enfranchising felons who've done their time. Today, we're dealing with the case that's before the Supreme Court right now is Louisiana versus Calles. And I don't know how much you've paid attention. This gets us to the question of districting. When legislatures draw those district lines, they put 760,000 people in each of those districts for their congressional districts. How do they do that in a way that does not violate the Voting Rights Act? And so in Louisiana had a map that had two primarily Black districts, majority Black districts, prior to 2022. And their population is about 1/3 Black. So if you've got 6 districts, 2 of them are primarily Black. The idea was you've satisfied the Voting Rights Act because Black voters can presumably control 2 of those 6 seats. In 2022, they redrew the map and got rid of one of those primarily Black districts. So, of course, voters sued, and the district court and the Fifth Circuit both found that the 2022 map violated Section 2 of the Voting Rights Act, that it did discriminate or abridge on the basis of race, how they drew those lines. So Louisiana was ordered to draw a new map in 2024, which added the additional Black district, majority Black district. White voters challenged that map as being a map drawn on the basis of race, and that's a violation of the Equal Protection Clause. So we've got a Voting Rights Act that says you can't discriminate on the basis of race, and we've got an Equal Protection Clause that says you can't discriminate on the basis of race. And the real question is, if we're trying to district in ways to protect party affiliations, which is what the Republican Party was doing in Louisiana, notice how the bright red is solidly Republican, blue is solidly Democrat. The 2022 map had 2 potential swing states because you split that Democratic district or that population. So the new map has the 2 majority Black districts, but it also has 4 very solidly Republican districts as a result. And this map is at the Supreme Court right now as to whether or not this map is a violation of the Voting Rights Act. And everybody predicted, they just heard oral arguments a week or so ago. Everybody predicts that the court's going to basically strike down Section 2 of the Voting Rights Act as being an unconstitutional infringement under the Equal Protection Clause. So they anticipate that that this map is going to be invalid as well, which tells you how do we get a map, right? How do we get a map that's valid? So what do we do when race and partisanship intersect? Because that's really the problem we have here. In the 2021 oral argument in Brnovich, which was a Voting Rights Act case, Arizona's Republican Party lawyer was asked what interest the Republican Party had in defending the Arizona voting restrictions. And the Republican Party lawyer said, because it puts us at a competitive disadvantage relative to Democrats. So clearly the Voting Rights Act and the prohibition on race-based dilution of the vote has an impact on the parties and who's going to end up with power. In Brnovich, the court declined to announce a test to govern all Section 2 challenges. They just simply said, well, it's enough to provide some guideposts. But now in Louisiana versus Cali, we're going to have to figure out what those guideposts are. And the court left intact Section 2 in 2021 in Brnovich, but we're not sure they're going to leave Section 2 intact after that. So the guideposts they came up with is the size of the burden created by this new regulation, the degree that this new rule deviates from past practices, and the size of the racial imbalance, and the overall level of opportunity afforded voters in considering all election rules. Because there's no question, right? Everybody who's in power wants to stay in power. And in order to do that, you want to make sure your voters show up to the polls and the other party's voters don't show up to the polls. So how do you make it difficult for the other party's voters to show up to the polls and keep your own? So really the battle these days, the court, as I think everybody recognizes, the court is pretty much decimating the Voting Rights Act. And so that leaves us with what kind of protections are there for the kind of rampant gerrymandering that we are beginning to see? And are there any protections for that? So partisan gerrymandering has been around for a long time, right? The term gerrymander comes from, I forget what year, it was around 1820, I think, when Massachusetts Governor Elbridge Gerry drew district lines, and they said it looked like a salamander. So it's a combination of the word Gerry and salamander, because his district looked like a salamander. So we have been doing partisan gerrymandering for centuries, and there's two main ways in which we gerrymander: packing and cracking. So you either pack all of the minority voters into one district, you give them that district, and then you crack any other minority voters and you spread them out among the other districts. So here this is just an example. We could have a 50-50 Democrat-Republican split. You can gerrymander it to have 3 Democratic districts and 1 Republican district, or 1 Democratic district and 3 Republican districts very easily. Or you can draw lines, and I think that's a bit naive, or I don't know, misleading to think that the straight lines is somehow a more impartial or neutral line drawing exercise. But if you're trying to create districts that reflect the overall state split, you could certainly do that. But no state legislature seems willing to do that. The independent districting commissions do try to create somewhat balanced districts. So the redistricting report card right now shows that, as you can see, which states are not doing well. I think California is about to be declared in the red, given that California is about to react based on today's vote. Is going to react to what Texas is doing. But you can see where you have lots of gerrymandering going on, and some that's a lot less. Of course, some of the districts, some of those states, North Dakota, Wyoming, and Montana, I think they only have 1 representative anyway. So no real gerrymandering going on there. This is an interesting slide that I pulled up for a different presentation I was doing. It came out after the 2016 election, and it was a group that wanted to repeal the 19th Amendment. That's the right of women to vote. And they pulled up a map and said, well, what would the election have looked like if just men voted? And what would the election have looked like if just women had voted? So people are looking at voting patterns and paying attention to things like this. Unfortunately, I'm hoping that the 19th Amendment is not going to be repealed. It would actually take a repeal, but there's an effort, a hashtag to do it, so you know it's going somewhere. So what has the Supreme Court said about redistricting? So redistricting is the one, what do I want to say? Of all of the restrictions that we saw, the poll taxes, the literacy tests, the ID requirements, those sorts of things, we have all of those in one bucket, and then we have redistricting. And really the how you draw your lines controls elections probably more than any of the rest of those restrictions, although maybe not entirely. So the Supreme Court has been asked to weigh in on the question of partisan gerrymandering, of drawing these lines to benefit your political party. And technically, drawing lines to benefit your political party doesn't violate the Voting Rights Act, because the Voting Rights Act is concerned with race. This is concerned with political party. In 1962, Baker versus Carr, the court said these apportionment cases, redistricting cases, are justiciable. That means we have jurisdiction to make sure that states don't go beyond what they should be doing. That we have jurisdiction to decide these cases and to set some ground rules. It did that in 1962. In 64, they said in Westbury versus Sanders, federal districts have to have nearly equal proportions, because from 1898 to 1964, a lot of districts had not been redrawn. And so you had huge influxes of population into urban centers, you had loss of population in rural areas, and you had very malapportioned districts. The court in 1964 said one person, one vote. You've got to draw those districts to roughly equally divide up the population for federal districts. And in Reynolds versus Simmons 64, they said you need to do the same thing for state districts, because that hadn't been, that also, as we know in Florida, the pork chop gang and all of the crowd out on the panhandle, they had so much more power than Miami, South Florida. In almost 20 years later, in Davis versus Vandemer, the court ruled that partisan gerrymandering claims are justiciable under equal protection. So now they're not going to say that Democrats or Republicans or independents are a suspect class and they get heightened scrutiny and the Equal Protection Clause really cares about them very much. But they did say that the right to vote is a fundamental right. And you have a right not to have your right to vote diluted. People just do, right? And so, but Indiana's gerrymander was okay. We didn't think it went too far. It didn't really dilute the right to vote. And so we remain convinced that we have the power, the jurisdiction to decide, to weigh in on partisan gerrymandering, but we can't really come up with a rule. I'm having a really hard time coming up with a standard for when we know you've gone too far. A state has gone too far. Now, in Thornburg versus Gingles in 1986, the court did rule that North Carolina's districting plan diluted the votes of Black voters. So it was in 1986 that we see the Voting Rights Act and this idea of gerrymandering, just the drawing of lines, could be a problem. But in 2004, again, another partisan gerrymandering case in Veith versus Jubileer, the court said, well, we agree that we have jurisdiction, but we're really struggling coming up with a standard. We can't come up with a rule on when a state has overstepped. And so we can't give you any guidelines, states, but we'll know it when we see it. If you do a really bad gerrymandering, we'll know it when we see it, but we can't give you any guidelines, mainly because we had, I think, 6 different opinions, and the justices can't agree on a rule for when a state has gone too far in its partisan gerrymandering. In 2015, in the Arizona State Legislature case, they ruled that redistricting is a legislative function, but it can include a public referendum and the governor and stuff like that. So that's good. So now we know that independent redistricting commissions do satisfy that legislature requirement of Article 4 of the Constitution. In 2016, in Evanwell versus Abbott, they ruled that states can use total population counts for redistricting despite large populations of non-voting residents. Now, this has been a topic of debate. If you have a district that has a lot of children, non-voting immigrants, and incarcerated population, right, which you have in some of these rural counties, then you have a fairly small number of voters. And the states have debated whether you use total number of voters, or maybe, I don't know how you would have fair representation if you're only looking at number of voters. So Supreme Court said, no. You look at total number of people in your district. That's how we come up with that 760,000. You don't get to draw up the lines based on populations of children. But 2019 is when all of this came to an end. In Rucho versus Common Cause, the court ruled that partisan gerrymandering claims present non-justiciable political questions. In other words, we can't come up. We've been trying since 1962, when we held that partisan gerrymandering was a justiciable issue, something that we have jurisdiction over. 2019, we decided we give up. We give up. We cannot come up with a standard. We can't come up with a rule. We can't agree among ourselves. Some of us think that this is a political question, which no duh, political gerrymandering would be a political question. So the court has this political question doctrine where they say if it's politics, it's not law. We're not involved. So as of 2019, basically the federal courthouse doors are closed for partisan gerrymandering claims. The court will not consider them. So that puts everything into the states. So the recent gerrymandering battles, I just looked up there were lots of maps on the internet I could find. But there's been a lot of gerrymandering shenanigans since 2019, although Wisconsin was doing it long before that. But you look at Wisconsin, for instance, in their state legislature in 2012, they won. Republicans got 60 out of 99 assembly seats, despite Democrats having a majority of the statewide vote. And then once you're gerrymandered for the state legislature, then the state legislature can gerrymander for your federal districts, for your federal congressional districts. In 2020, Utah Republicans divided Salt Lake City. They cracked it so that it was completely diluted to create 4 Republican seats. Tennessee divided Nashville to ensure that all of Tennessee's 7 seats were GOP. Illinois is the most aggressive Democratic gerrymandering state. It has a district that splits 6 counties and to maintain a 14-3 Democratic edge. Florida just eliminated a majority Black district in Jacksonville by cracking it. Let's see. And then once Republicans controlled the North Carolina Supreme Court, they reversed an opinion on partisan gerrymandering under state law. So North Carolina state law had said you can't have it be too partisan. North Carolina Supreme Court reversed. So they ensured a 10 GOP seat out of 14 in a state with a 50-50 population. And Ohio packing ensures that the GOP controls 13 out of 15 seats. And Indiana cracked Indianapolis. So this has been since 2019 a pretty significant amount of gerrymandering that Wisconsin one preceded it. And I don't know about you, I can't come up with it. I mean, I've read Rucho, I've read Veith, I've read Baker versus Carr. I don't know what kind of test I would come up with if I were on the Supreme Court and I were asked to think about when does a partisan gerrymander become a real problem? Because if you gerrymander the state legislature and they're entrenched, then they can gerrymander the congressional seats, and it could take decades to undo that, to break that state gerrymander in order to get us out. And given that our population, we're really fairly split in this country. Fairly split when we do have a fairly split House of Representatives, but right now they show 45% nationwide Democrats to 46% Republicans. So very, very evenly split. And yet, if you look at control based on state house and the ability to gerrymander, you see that states that have a Democratic trifecta control 75 House seats. States that have a Republican trifecta control 187 House seats. Then you have 46 House seats are in states that have a split state government. 121 are in commissions. states that have commissions. And that seems to be the trend. I think it's a good idea. And then you have 6 states that only have one. So it's an at-large election anyway. So thinking about, I don't know, looking at how the vote went, in 2024, Harris versus Trump, the number of electoral votes, and then thinking, my thought was, well, if we imagine that the districting should roughly match the population. So if we've got a 50-50 state split, we should be pretty close to 50-50 House members, congressional members. And on that standard, close, don't make it, the majority can have, because you can't have 0.3 of a seat, majority can have the extra seat. But based on just that rule, based on percentage of the voting population to the number of seats we hold, Florida is gerrymandered to create 3 extra Republican seats. It has 20 Republican versus 8 Democrats. Michigan is gerrymandered to have 2 extra Republican seats, but it doesn't work anymore because of population changes. So Michigan didn't do a very good job. Virginia was very gerrymandered, but now they have an independent commission. So they seem to be pretty good. North Carolina has 4 extra Republican seats in a 50-50 state. Ohio has 3 extra. Illinois has 4 extra Democrat seats. California has 4 extra Democrat seats, but it will get more if on the ballot today is a provision to allow to sort of remove the Fair Commission and allow for gerrymandering. And if the people vote for that, then California promises they're going to do 4 or 5 more Democratic seats in order to counteract Texas, which has got 5 more seats as a result of redistricting. Pennsylvania has 4 extra Republican seats, even though it's a 50-50 state. So if you look at how gerrymandered we are, there's probably 22 extra Republican seats and 8 extra Democratic seats, with 4 more potential in California, just as a result of partisan gerrymandering. So what's the answer? I don't know what the answer is. But on October 29th, Florida's GOP executive director, Bill Helmich, said he could redistrict Democrats here out of existence over a weekend in the state of Florida. He told the Capitol Tiger Bay Club on October 29th that if the Florida legislature were to call on him to help with redistricting, he could sit down over a weekend and draw a map where there's not a single Democratic member of Congress from Florida. And I'm sure he could. But I don't know what the answer is. I don't know what the answer is. Everybody has been gerrymandering since the beginning. Do we go back to statewide elections like we do for senators? I can't imagine voting for 28 representatives. How do we, and if when the state assembly seats are gerrymandered, it's hard to control the congressional seats. So that's where we stand right now. Be interesting to see what the Supreme Court does in Louisiana versus Cali's, but it sounds like the Voting Rights Act is going to be out as a tool, and the Supreme Court has said, hands off. We have no jurisdiction over partisan gerrymandering. So where, if anywhere, is there any remedy for anybody other than the intense partisanship of every Democratic state's going to gerrymander themselves and every Republican state's going to gerrymander itself, and we're going to be stuck for decades. And on that cheerful note, that's all I have. Thanks. And Pam's going to run around with the mic. Questions? Okay.
I think we've all been in other countries with vivid political systems and political campaigns. is gerrymandering an American phenomenon, or is it it's everywhere? It just has to do with the process of people wanting to get more people voting.
Yeah, I mean, whenever you draw a line, whenever you say there's this district and that district, there's the potential, you are gerrymandering to some extent. You have to, right? There's no really neutral way to draw the lines. So they've come up with things like go with natural boundaries, go with contiguous communities, go with county lines, go with as many of those as possible. But those are not neutral either.
Hi. There's an example right in Florida between Palm Beach and Martin County. And there's a golfing community, which I know about, that is in St. Lucie, and people have to vote in St. Lucie. However, the advertising was for the town in Martin County, which is a different type of county. So when these people wanted to go vote, they were voting in a district that, wasn't theirs. And the other thing is there was gerrymandering in that area because our representative that was supposedly Republican was Democratic. So yeah. It's going on.
Oh, it's going on everywhere. And Florida is one of the worst, right? I kept saying, what are the 10 worst gerrymandered states? And Florida didn't get worst, but it was of the 10 worst. Yeah, they cracked Gainesville. And I think they cracked part of Tampa as well.
Thank you. That was a good talk, Danaya. Quick question. The fair district standards that were passed in 2010, what happens to them now? Are they totally?
I mean, it's just it's one thing to say you have to have fair districts. And the voters are like, yes, we want fair districts, because voters, we're basically fair. I don't think the California referendum is going to pass, because even though voters see bad things going on, we all believe we should play by fair rules, I think. But if you don't have the courts stopping you, and you've gutted the Voting Rights Act, and partisan gerrymandering is off the table, the only avenue is going to be maybe the Equal Protection Clause that says your fundamental right to vote has been diluted. But really, there's no enforcement mechanism.
Yeah.
And there's a lot of, that's what's basically happened, is we've never really had good enforcement, but we have even less enforcement now. And at least under the Voting Rights Act's pre-clearance requirements, at least the 15 states that had a bad history had to get pre-approval before they made changes. But districting is different from all of these other, I mean, like districting how you district and draw those lines can affect, can dilute Black voters and can violate the Voting Rights Act. Absolutely. But there's a whole lot of other things that also come in under the Voting Rights Act. And so the Supreme Court has said, as long as you say it's partisan gerrymandering, we don't care.
One quick question also. I noticed, and I never picked this up before, the Voting Rights Act in both Section 2 and I think 5 refer to race and color.
And color.
And what was the thinking about making that differentiation, and has that been picked up in case law?
I mean, I think that's recognized in the Civil Rights Act. It's recognized in a lot of different things that race is a hard category to define. And so, as is color, basically. But the idea here is, notice what's not there is we're not sex, veteran status, political opinion, disability now was added. But there's so many categories in your regular Civil Rights Act: religion, national origin. All of those are now parts of our Civil Rights Act that say, you can't discriminate on the basis of all of those. You can't discriminate on the basis of veteran status, right? All these things. But the Voting Rights Act only has race or color. That's how they define it. Which I just think is fascinating. That it has not been expanded to include other categories of protected identity groups.
Well, if you did a before and after analysis, does gerrymandering improve or inhibit voter turnout? I mean, that should be the kind of if it's
Yeah.
if you really need a gerrymandering, you should be rewarded by more people
Well,
voting.
I mean, I think a lot of people don't turn out because they feel like their vote doesn't count. Right. And so that's really the question. And can we say is the reason people are not voting is because they feel like the vote doesn't count? And I'll be honest, right? I'm a Democrat and I'm voting in Florida. My vote doesn't count. My brother's a Republican in California and his vote doesn't count. If we could switch, but why? But that doesn't mean I don't vote though, right? I absolutely vote for absolutely every single election. But a lot of people don't. And a lot of them will say, well, my vote doesn't matter. And it doesn't when you think about 14 million people in the state of Florida. And even though there's a lot of felons and children and immigrants who aren't allowed to vote. So 14 million is not the voting population, but still you feel like you're just one of millions. My vote doesn't matter. Why should I get out of bed and go to the polls? And I don't know, but I think the gerrymandering doesn't help. When I look at something and I say the state is split 50-50 and you've got 14 of one party's seats and 3 of the other party's seats, that just smells wrong to me. But I can't come up with, and maybe what the court could have said, you've got to draw lines that are going to better approximate the statewide population. So if you have too much deviation, more than a 10% deviation, that should be good enough. But it's like, they throw up their hands. We can't come up with a standard.
Any other questions in the room?
But today's voting day.
Anything
So we've
online?
got 2 governors.
Any questions online? No. Okay.
Roy
Roy wants
has
to say something.
All right.
I just want to thank Danaya for what she's done over the last 2 terms. I got credit for being a co-facilitator, but Danaya has done it all. She's gotten all the speakers, including having to draft herself for this last session.
Yes.
I think the real problem is the political question doctrine.
Yeah. Yeah. The political question. So it's interesting because there's nothing in the Constitution that says
No.
that the court, there is a requirement the court can only deal with cases or controversies. So it can't deal with hypotheticals. Can't just resolve a hypothetical issue that's not really a case or a controversy. But there's no reason why they couldn't resolve this. We have a provision in the Constitution that says you're guaranteed a Republican form of government. That means you've got people who represent you and go to Tallahassee or go to Washington and represent you. So they could, but they've said, no.
Yeah. Well, again, thank you for being here. I think it's been a terrific 2 terms of this issue of hot topics. So thank you so much.
Thank you all for coming.